Returning to my Coin Lady channel, I am pleased to see you again. In the Zakhanov vs. Ripple complaint, a judge from the U.S. District Court for the D.C. referred the case to a magistrate judge for settlement after the court partially granted and partially denied the defendant's motion for summary judgment. The judge also ignored the Southern District of New York Court's ruling that XRP programmatic sales are not securities, leading to a contentious disagreement in the XRP immunity Ripple class action lawsuit as the parties sought a settlement. Judge Phyllis Hamilton of the Northern District of California District Court handed down a ruling on the class action lawsuit involving Ripple's SRP and CEO Brad Garlinghouse. Although the court granted the defendant's motion for summary judgment on the federal and state class claims, the defendants were denied summary judgment on the individual claim that plaintiff Stostick had filed against them under California law. This is an additional matter to consider. Both the Ripple and plaintiff motions to exclude Stephen P. Feinstein's and M. Laurentius's testimony were deemed moot because they were considered to be irrelevant. To further address the parties' dispute, Judge Phyllis Hamilton issued a supplementary order requesting that Magistrate Judge Robert Ellman be sent the Ripple matter. The summary judgment that Judge Torres of the Southern District of New York handed down regarding the sales of XRP programming was rejected by Judge Hamilton. According to him, investors were counting on Ripple's efforts to generate profits. Concerns about XRP's status as a non-security asset have been heightened by the XRP Army's speculation about the impact of Judge Hamilton's decision to sideline Judge Torres on the Ripple v. SEC lawsuit. According to Mark Vagel, a former SEC attorney, the biggest threat to Ripple is the chance that the SEC may use this California case to appeal Judge Torres's summary decision on XRP to the Second Circuit. On the other hand, before deciding on a fraud case, the court must ascertain whether XRP sales qualified as securities. Bill Morgan and Fagel both brought up the fact that, even if Ripple is determined to have broken the law, the lawsuit may not have far-reaching consequences. Ripple and the SEC's conflict has recently escalated. Lately, a number of key claims contained in a class action lawsuit against Ripple were rejected by the U.S. District Court for the Northern District of California. Judge Phyllis Hamilton granted Ripple's motion for summary judgment on federal class claims for unregistered and state law securities, effectively dismissing most class action accusations against the company in the U.S. This was a procedural victory for the company. Stuart Alderete, Ripple's chief legal officer, expressed satisfaction with the dismissal in a statement. The jury will decide on the XRP security status. Despite the dismissals, the court did not rule on the issue of whether XRP constitutes a security. A jury will have to decide if XRP passes the Howey test, which is a crucial decision in this matter. A California judge has also ordered the trial of Ripple CEO Brad Garlinghouse in a civil securities case. United States District Court for the Northern District of California ruled that the trial would focus on determining whether or not Garlinghouse's actions influenced the decisions that investors made, as the lawsuit alleges that he made false representations in 2017 about the sales of XRP, in contrast to Ripple's partial success in New York. The court reached this conclusion after rejecting 4 additional claims. The goal of this trial is to determine, by a split jury, whether XRP should be considered a security under the law. In the Southern District of New York, there is a discrepancy between Judge Hamilton's judgment and Judge Torres's analysis. Judge Torres ruled that retail investors were misled into thinking XRP was a security since the token's little value and the likelihood of a negative jury verdict meant it did not meet all the requirements of the Howey test. The likelihood of a settlement, impending deadlines, and motions to consider were all highlighted by legal analyst Fred Rispoli in the California case. With a deadline of July 8, 2024, the court has mandated that the parties re-evaluate their requests to seal parts of their briefs, limited to protect only one display. The court will then decide on these motions in their final decision. While a disaster could happen, the SEC could also achieve a magnificent victory in July 2023. Judge Elisa Torres of the Second Circuit delivered a mixed verdict that sparked the debate. In it, she found that XRP tokens sold to regular customers are not securities, but she found that Ripple violated the law when it dealt with institutional investors. This decision has muddied the waters of Bitcoin regulation while also giving each side a victory. An ex-SEC employee named Christina Littman hinted in May 2024 that the SEC might not look into the matter further. This strategy stands in stark contrast to previous court decisions, such as Judge Jed Rakoff's decision in the Terraform Labs case, which rejected identical arguments at the same time that Ripple is trying to lower the possible fines, estimated to reach $2 billion. The SEC was established to safeguard investors, according to Hogan, who is an XRP supporter, but such heavy fines would force Ripple to dump a lot of XRP, which would hurt those investors. Was given the Jeremy Hogan expressed his skepticism in a post about the SEC's chances of winning its current legal battle with Ripple. He said that even if the SEC wins its appeal, the case could still end badly. The SEC is currently appealing to the U.S. Court of Appeals for the Second Circuit. Although a victory is possible, it is highly likely that the case will be sent back to the trial court for further factual evaluations because the SEC will have a hard time with the Ripple appeal and, according to Hogan's opinion, the complexity of the case suggests that the Securities and Exchange Commission (BC) may have trouble winning the appeal. The SEC's early success in this case may pave the way for more drawn-out judicial proceedings in the future. Judge Annalisa Torres's ruling at a district court in July 2023 brought the situation to light. The judge determined that XRP tokens, when offered to ordinary investors on exchanges, do not constitute securities. The sale of Ripple tokens to large financial institutions was determined to be in violation of federal securities regulations. The fact that different courts have come to different conclusions makes finding the most desirable stance more challenging, according to the same ruling. According to Christina Littman, a former division chief of the Securities and Exchange Commission, the SEC may decide not to appeal the Ripple case to a higher court, which might mean that the district court will continue to consider Torres' ruling. Bye for now, and please hit that like button and subscribe to my channel.